Okay, strap in, everyone. Today, we are taking a deep dive into the world of legal argumentation.
Um, yeah.
We've got these fascinating excerpts from The Tools of Argument by Professor Joel Trachtman.
Right.
And it's going to be really interesting
Yes.
because this stuff, it's not just for lawyers,
Well, yeah,
right?
absolutely not.
I mean, these are tools of thinking
Mm-hmm.
that apply to, like, every field.
Yeah, these are really the tools of persuasion and
Yeah.
critical thinking
Mhm.
that can help you level up in any area.
Absolutely.
It's fascinating how these
Yeah.
tools, they're really rooted in
Mhm.
the structure of logic
Yeah.
and argumentation. It doesn't matter if you're like debating with a friend
Right.
or you're trying to negotiate a deal
Mhm.
or even just understanding a complex issue.
Right.
These concepts,
Mhm.
they can really help you see clearly
interesting.
and make your point in a way that's
Yeah.
more impactful.
So Trachtman, he starts by defining what law is.
Right.
I think we all have this kind of vague sense of like rules and stuff, but he goes deeper than that.
Yeah.
He says it's about creating security, predictability.
Right.
It's knowing when you've got the power of the state on your side, but also like how to win an argument
Yeah.
without having to, call the cops, right?
Exactly.
So what's really fascinating to me, Trachtman emphasizes how different
Yeah.
legal systems are.
Yeah.
And he points out that procedure is just as important
Yes.
as the actual outcome.
Yes.
Do you remember that example from the Paris Peace Talks
Oh, yes.
where they were arguing about the shape of the table?
Yes, absolutely. That's a classic example.
That's lawyers understanding
Right.
that how the process works
Yes.
can totally change the game.
Yes. And how much power there is in the procedure.
That's wild.
Yeah.
It makes you think about, like, how much strategy
Yeah.
goes into even the tiniest details.
Right. Every little thing matters.
So, speaking of strategy, how do lawyers think?
Yeah. So Trachtman breaks it down into two main things:
Okay.
analysis and synthesis.
Okay.
He argues that lawyers are like masters of deconstruction, right?
Yeah.
They take these arguments apart.
Right.
They examine every case to see if it fits the rules, and then they put it all back together.
So it's like they're taking apart a clock
Yes.
to see how it works.
Exactly. Except the clock is a legal argument.
Okay, but what's the practical use of
Right.
all this clockwork? You know what I mean?
Sure.
Does this help us win arguments?
Oh, absolutely.
Yeah.
This kind of thinking forces clarity, and it helps you spot the weak points
Right.
in someone else's argument.
Okay.
So you're not falling for those, vague claims anymore.
Gotcha.
You can really pinpoint where the logic breaks down.
So that's the foundation.
Mm-hmm.
What law is, why it matters, and that legal thinking process.
Right.
But then Trachtman gives us 15
Yes.
procedural arguments.
Mm-hmm.
And this is where things get really juicy, right?
Because there it gets good.
He's basically saying you can win
Yes.
before you even get to the heart of the matter
Yes.
if you know how to play the system.
If you know the rules of the game,
Yes.
it's about understanding those rules and using them strategically to your advantage.
Like he talks about forum shopping,
Yes. Forum shopping, that's a big
where you choose the court.
Right. You choose the specific court or jurisdiction that gives you the upper hand.
Wow. Okay, and then there's standing.
Right.
Who even has the right to bring a case in the first place?
Exactly. Who is even allowed in the room?
It's like choosing your battleground.
Yes.
Really carefully.
Absolutely.
One that really stood out to me
Yeah.
was characterizing the case.
Oh, yes.
So Trachtman argues that just framing the issue differently can totally predetermine the outcome.
Yeah.
It's amazing how powerful language is and perception.
Oh, it's credible, yeah.
Like he gives a great example of
Yeah.
this whole debate about flame retardant chemicals
Right.
and how the chemical companies reframed it as a civil rights concern.
Yes, that's powerful.
And arguing that, if we restrict these chemicals, it would hurt minorities
Right.
who are more at risk in fires, statistically.
Exactly. Talk about changing the game.
Wow, that's a game changer.
Yeah.
It shows how just shifting the perspective can totally change how you view the argument.
Completely.
Okay, so we've got this forum, shopping, and choosing the right court. But how does jurisdiction work?
Right.
This sounds really complicated.
So jurisdiction is all about whether a court actually has the power to decide a case.
Okay.
And it can get very complicated, especially, with different countries or states.
Yeah.
You remember that Bhopal disaster in India, there was a huge debate about whether the case against Union Carbide should be heard in the U.S. or in India. The outcome could have been totally different, depending on where it landed.
Yeah, that's a stark reminder of why understanding these procedural tools is crucial. This is not just theory. This has real-world impact.
Real-world consequences.
What are some of the, nuances of jurisdiction that our listeners should know?
Okay, so first you've got subject matter jurisdiction, right? That means the court has to be the right type PE to handle the issue. A small claims court can't decide a patent dispute, right?
Makes sense.
And then you have personal jurisdiction. And this focuses on whether the defendant has a strong enough connection to the state where the lawsuit's filed. Like Trachtman uses the Chevron case as an example. Where Chevron tried to argue that an Ecuadorian court had no power over them, even though the environmental damage happened in Ecuador.
Wow. Yeah, I can imagine the legal headaches for international companies trying to navigate all this. So it sounds like preemptive planning is key.
Oh, absolutely. Anticipating these issues and using tools like form selection clauses in contracts to avoid these battles later on.
Smart. Just avoid that whole headache.
Exactly.
Okay, so we've covered jurisdiction, choosing the right court.
Yes.
What about standing? Who gets to bring a case to court?
Yes, standing is all about having the right to even be in court. And it's tricky because sometimes, someone's been harmed, but they might not actually have the standing to sue. Oh, interesting.
Think of it like a VIP area. You need the right credentials to get in.
Trachtman uses that famous environmental case, right?
Yes. Sierra Club v. Morton.
Yeah.
So the Sierra Club wanted to stop Disney from building this ski resort in Mineral King Valley, which was this beautiful, pristine area. But the Supreme Court said, nope, you don't have standing. Because they hadn't shown that their members would be directly harmed.
Interesting.
So they needed to find people who actually USD the valley to be the plaintiffs.
So it's not enough to care about an issue. You have to be personally affected to have a legal voice.
That's a big takeaway.
That's an important point. Of course, there are always exceptions and nuances
of course,
standing. But the main point is there's another hurdle you have to get over when you try to bring a case. Exactly. It's like a legal obstacle course.
Okay, so we've covered some serious tools for arguing within the legal system itself. But there's more to unpack here.
Yes.
Trachtman spends a whole chapter on interpreting texts, laws, contracts, anything with words, really.
Because words are the tools we use.
Yeah, exactly. And I know you love this stuff.
Oh, I do.
He starts by talking about plain meaning. Which seems straightforward until it isn't.
Yeah, it's deceptive.
I think we all love the idea of sticking to the simple meaning of the words. But as Trachtman points out, words can be really slippery.
Oh, they can be so tricky.
I mean, dictionaries have multiple definitions. And even the dictionary definition might not make sense in the context of, like, a contract.
It all depends on the context.
He gives that hilarious example of a clothing manufacturer and a customer who used the word inflammable in their contract.
And they thought it meant that it couldn't catch fire.
That it was not flammable.
Clearly someone missed that day in class.
Oh, dear. That's a classic example of how even simple words can lead to huge misunderstanding.
Huge problems.
So Trachtman emphasizes that context is everything.
It is, absolutely.
You can't just look at words in isolation.
No, they exist in a whole web of meaning.
It's like those optical illusions where the same image can look like two different things.
Exactly.
Okay, now sometimes you have to go beyond the dictionary. What about this whole idea of original intent when interpreting texts?
Oh, yes.
Especially, important ones, like the Constitution.
The Constitution. Yeah, that's a big one.
Original intent. This is a huge debate, especially in legal circles. So the idea is that we should try to understand what the authors intended it to mean rather than just focusing on the words.
The literal words.
It's like being a historical detective.
Yes, it is. It's like, what were they really trying to say?
Yeah, but isn't that a slippery slope?
It can be, yeah.
Like, how can we truly know what someone intended?
Right.
Especially if they lived, centuries ago.
Right, and they didn't leave us a detailed explanation.
Exactly.
Every single word.
It seems like there's a lot of room for interpretation.
Yeah, absolutely.
And even, manipulation.
Yeah, that's one of the main criticisms of originalism.
Right.
It can be very difficult to determine what that original intent was.
Yeah.
And, there's a lot of room for debate.
Right.
And potential bias to creep in.
Plus, times change.
Oh, they do, yeah.
I mean, what made sense in the 18th century might not apply to modern society.
Completely different world.
Trachtman uses the Second Amendment as an example.
Right. The right to bear arms.
Right. So if we were strict about original intent, maybe people would only have the right to muskets.
That's right, because that's what they had back then.
I mean, can you imagine?
That's a fascinating thought experiment.
So if original intent is problematic, what are some other approaches?
So Trachtman discusses a few other approaches.
Okay.
One is this idea of evolution in interpretation.
Evolution, okay. So this approach recognizes that the meaning of a text can change over time to reflect societal changes.
Right.
It's a more flexible approach.
Yeah, it is.
But some argue that it gives judges too much power.
Yes, that is the criticism.
To basically rewrite laws.
Right, because who gets to decide how it's evolved?
And so the debate continues.
It does.
Trachtman uses the Supreme Court's changing interpretation of cruel and unusual punishment as an example.
Right. What was considered cruel centuries ago might be viewed very differently today.
Totally.
Right. So this approach allows the law to adapt to changing moral standards.
Which is really interesting.
It is, yeah.
It makes sense in some cases, but I can also see how it creates instability.
Yeah, definitely.
If the meaning is always shifting.
Can be tricky, yeah.
So what other tools for interpretation?
Okay, so he dives into what's called the four corners rule.
Four corners.
Okay, which, it sounds kind of like a magical incantation or something.
It does sound a little bit like that.
But essentially it states that when you're interpreting a contract, you can only consider what's actually written within that contract. No outside evidence, no discussions, nothing allowed.
So it's like what you signed is what you get.
That's it.
No matter what.
Well, as always, there are some exceptions.
Right.
Trachtman points out that if the language is ambiguous or if there's evidence of fraud, then you might be able to look beyond the four corners.
I see. So it's not always black and white?
Not always.
What I'm getting from this is that interpreting texts, it's not about finding one right answer.
That's right.
Is that accurate?
Yeah, you hit the nail on the head.
Okay.
It's often about using these tools strategically to advocate for the interpretation that benefits your side.
Right.
It's like a game of chess, you know? You're figuring out which moves will give you the advantage.
I like that. Okay.
Yeah.
So Trachtman even goes into these really interesting techniques.
Yes.
Like extensional pruning, which sounds more like a gardening term.
I know, right? It sounds like we should be out in the yard.
Right, exactly. But what is extensional pruning?
Okay. So extensional pruning, it's about how specific wording can limit the scope of a rule.
Okay.
So imagine a contract that says you can park cars in this lot. Now, someone could argue, well, it doesn't say anything about trucks or motorcycles, so those aren't allowed.
Even though they're technically vehicles.
Even though, they're vehicles. Wow. So it's all about exploiting those loopholes.
Sneaky.
Yeah.
But clever.
Yeah.
It makes you realize how important, precision is when you're drafting these contracts.
Every word matters.
Every word matters.
Yeah, it can have consequences.
Yeah.
And Trachtman highlights the role of lawyers.
Right.
In either identifying and eliminating those loopholes or, on the other hand, using them.
So it's a constant battle of wits with language as the weapon.
Absolutely.
This is fascinating.
It is.
Okay. So then he goes on to this idea of constructing missing terms.
Right.
What does that mean?
So this is about those situations where a contract or law doesn't directly address a specific situation that comes up. And someone might argue, well, the missing term should be filled in or constructed based on what the authors would have intended.
So it's like reading between the lines, but with like legal implications.
Yeah, and it becomes very strategic.
Oh, I bet.
Right, because the party who benefits from a certain interpretation will, of course, argue for that, and the other side will push back.
Yeah, of course.
They'll say, no, the contract should just be taken as it is.
Right.
So there's a lot of potential for debate.
Okay, speaking of maneuvering, where do default outcomes fit in?
Oh, yeah.
Trachtman mentions that too.
Default outcomes are like what happens if the contract doesn't address the issue.
Okay.
And Trachtman says, understanding that default outcome, it gives you leverage in negotiations.
Oh, how so?
Because if the default benefits you, you might not even bring it up.
Right.
But if it puts a burden on you, then you want to make sure you're compensated for that.
I see. So it's about knowing the lay of the land.
Exactly.
If it works in your favor, you can sit back and let it play out.
Right.
But if it doesn't...
You got to be proactive. You got to negotiate.
Yeah. This whole world of contract interpretation is so interesting.
It is.
What other techniques?
Okay, so he also talks about this idea of interpretation and morality.
Interpretation and morality. Okay.
Yeah. And this raises the question of whether a judge's personal views should influence how they interpret the law.
That's a big question.
It is.
I mean, it makes you wonder how objective legal interpretation really is.
It's a thorny issue.
I mean, everyone brings their own perspectives.
Oh, they do, yeah.
Right.
And that's a constant tension.
Right.
Some people say judges should just stick to the letter of the law.
Right.
Others say, well, it's impossible to separate morality from interpretation.
Right.
Trachtman uses the classic example of Socrates,
who
chose to follow the law even though he believed the judgment against him was wrong.
That's a powerful example of the conflict between, like, the law and your own personal conscience.
Absolutely.
It makes you think about those situations where the law might feel unjust, but you still have to operate within its boundaries.
Right. It's a tough question.
Yeah, it's a dilemma. It's been debated for centuries.
For centuries, yeah.
Okay, so we've covered a lot of ground on interpreting texts.
Yes.
And it's clear that there's more to it than meets the eye.
Absolutely.
But there are even more techniques. What about this concept of effet utile?
Oh, yeah.
That sounds intriguing.
Effet utile. It's a French term.
Oh, okay.
But it means that every word in a contract or law should be given meaning and purpose.
So we shouldn't assume that anything is filler?
Nothing is wasted.
Every word has its place.
It's like a legal haiku.
Okay, I like that.
Right. Every word is carefully chosen and important.
Okay.
This principle is related to some others that Trachtman talks about, like avoiding redundancy and assuming consistent usage.
Those sound familiar.
They do, right.
Yeah.
Like from high school English class.
Yeah, exactly. Yeah. What do they mean in a legal context?
So basically, we assume that the authors of the text chose their words carefully.
Right.
So if they use different words, we assume they meant different things.
Go ahead.
And if they use the same word in different parts of the text, we assume it means the same thing.
Okay, so it's about giving the authors credit for being, intelligent.
Yeah, intelligent and intentional.
And intentional.
Yeah.
When they were writing this.
Exactly.
But in the real world, draftsmen aren't perfect, are they?
Well, of course not, no.
Yeah.
And Trachtman acknowledges that, especially when it comes to, complex things.
Right.
But these principles, they give us a framework.
Right.
A way to approach the text.
Okay.
With a presumption of clarity.
It's like a starting point.
Exactly.
What about interpretation contra proferentum?
Ah, yes. That's a mouthful.
It is. I'm ready for a translation.
Okay, so it means that if the language in a contract is ambiguous, it should be interpreted against the person who drafted it.
Okay.
The idea is they had the power to make the language clear.
Right.
So if they didn't, they bear the consequences.
It's like a penalty?
Yeah, you could say that.
For sloppy drafting.
Right.
Like you didn't make it clear, so now it's going to be used against you.
Exactly.
Yeah.
But it also protects the other party who didn't have control over that wording.
That makes sense.
It kind of levels the playing field.
Yeah. Okay. What about expressio unius est exclusio alterius?
Okay, so that's Latin.
Yes, I figured. I'm ready for a translation.
It means the expression of one is the exclusion of others.
Okay.
And it's used for lists in contracts.
Okay.
So the idea is if you list certain things, it implies that you've excluded the things you didn't list.
Right. Trachtman uses that example, right, of a contract that says boats on a lake, but doesn't say kayaks.
Exactly. So someone could argue that kayaks are forbidden.
Because they're not on the list.
Exactly, because they weren't specifically included.
That's clever.
It is.
But also potentially frustrating.
Oh, yeah. If you're the kayak person, you're out of luck.
Yeah, exactly.
You got to be careful with those contracts.
It makes you realize how important it is to think through every possibility.
Absolutely.
Be really thorough when you're drafting things.
Yes. And Trachtman points out you can actually preempt these loopholes by using more inclusive language.
Right.
So phrases like including but not limited to
can really save you some headaches.
Smart move. Avoid those kayak controversies.
Absolutely.
Okay, speaking of controversies, Trachtman brings up reductio ad absurdum.
Oh, yes.
That sounds dramatic.
It does. It's a bit of a mouthful.
Yeah, what is that?
It's basically taking your opponent's argument and pushing it to its most extreme conclusion.
Okay.
To show why it doesn't make sense.
Oh, okay. I see.
So it's like you're showing how ridiculous the consequences would be.
He gives the example of arguing that people shouldn't be allowed to fly because they weren't born with wings.
Exactly. It's like, well, by that logic, people shouldn't ride bikes or cars either.
Yeah, because we don't have wheels.
Right. Exactly. So you expose the flaw in their argument.
It's a good way to shut down faulty reasoning.
Exactly.
Okay, so we've gone pretty deep on interpreting texts. But Trachtman keeps going.
He does, yes. He moves on to the power of precedent.
Precedent, yeah.
What's the main idea there?
So precedent is all about how past decisions shape the law.
Okay.
Lawyers love precedent.
Yeah.
Because it provides consistency and predictability.
Makes sense.
Right.
Like a roadmap.
Yeah, it's like a roadmap for legal arguments.
Okay.
It shows you what's been done before.
But it's not just about blindly following any old case, right?
No, you have to analyze it.
Right.
You have to figure out what the core principle is that's relevant to your situation.
So Trachtman talks about ratio decidendi.
Yes, ratio decidendi.
Which is the reasoning behind the decision, right?
Exactly. That's the part that creates binding precedent.
And then there's obiter dictum.
Right. Obiter dicta.
Those are like the extra comments.
Yeah, the little side notes.
Yeah.
They're interesting, but they don't carry the same weight.
Okay.
They're not legally binding.
Okay, so precedent can be a powerful tool.
Right.
But it also requires, like, careful analysis.
Yeah, absolutely. You can't just blindly follow the past.
You have to understand the nuances.
Yeah.
And then there's the question of when you break from precedent.
Right, when you say, no, this doesn't apply anymore.
Exactly. Sometimes times change, and the old precedent just doesn't make sense.
It's outdated.
Trachtman actually makes an interesting point.
Yeah.
About how even choosing not to decide is a form of deciding.
Yes. That's powerful.
Right.
By not overturning a precedent,
yeah,
the court is basically reaffirming its power.
It's subtle, but it's significant.
Yeah.
Okay, so we've talked about precedent, how to apply it, when to break from it.
Right.
What else is in this section?
Okay, so Trachtman also discusses the level of specificity in the original rule.
Okay.
So the more specific the rule, the less room there is for interpretation, the more predictable the outcome.
It's like having a detailed instruction manual.
Yes, exactly.
Versus like a vague set of guidelines.
Right.
But trying to create rules for every situation.
Yeah, that would be a nightmare.
That would be a never-ending legal document.
Right. Endless, yeah.
So that's where the common law comes in.
Right. The common law allows judges to fill in the gaps.
Right.
And they create precedent over time.
Okay.
Which eventually leads to more specificity.
So it's a constantly evolving system.
It is, yes.
It's about having some clear rules.
Right.
But also some flexibility.
Absolutely. You need both.
And finally, in this section on precedent, Trachtman talks about citations.
Oh, yes, the citation.
Notes, those footnotes.
I know they can be dense and intimidating.
Oh, they can be very intimidating.
Yeah, but they serve a purpose.
They do. They're important.
What's the purpose?
They're like the show your work of legal arguments.
Okay, I like that. Right, they allow you to check the sources. You can see the basis for the claims.
It's about transparency.
Yes.
And accountability.
Exactly.
It's like leaving a trail of breadcrumbs to show how you got there.
Yeah. And it also signals the strength of your argument to your opponent.
Right.
Because if you've got these solid citations, it can be very persuasive.
That's like saying, I did my research.
Yes, I've got the receipts to prove it.
Here's my evidence.
Yeah.
Okay, so we've covered legal thinking, procedural arguments, interpreting text, power of precedent.
Right.
But Trachtman doesn't stop there.
He keeps going.
He also dedicates a whole chapter to arguing about facts.
Facts, yes.
And I know you have thoughts on this.
I do because, I think a lot of people think that facts are just objective truth.
Right, black and white.
Right.
But how the facts are presented, which facts are emphasized, that can be incredibly strategic.
It's like painting a picture. You choose which colors to use and how to arrange them.
Right, to create a certain effect.
Create an impression, yeah.
So Trachtman emphasizes salience.
Yes, salience.
It's not just any fact.
Right.
It's about which facts matter.
It's about what's relevant to the legal issue.
He gives that example of the corporation suing an individual.
Right.
And the individual's lawyer might try to focus on the power imbalance.
Right, the David and Goliath kind of thing.
Right. But that's not legally relevant to whether the individual caused harm.
Right.
So it's about separating the emotional or political arguments from the legal one.
Exactly. Stay focused on the legal principles.
And then there's the whole issue of evidence.
Evidence, yes.
Which Trachtman goes into in detail.
Yeah, he does.
Evidence is crucial.
It is.
But it can also be very tricky.
It's tricky.
Right. What counts as admissible evidence?
Right. What can you even use?
How do you interpret it? It's like a legal puzzle.
It is. You're piecing together the clues.
So Trachtman talks about those missing links in arguments.
Right. You might have some evidence, but you need those missing pieces to connect it all.
To make it a story.
To create a convincing story, yeah.
He gives the example of the murder case.
Right.
Where you have the video of the defendant shooting the victim.
Right.
But you still need to prove that the victim died because of that gunshot.
That it was the cause, yeah.
Not some other factor.
Right. It's not enough to just show the act.
So even strong evidence can have gaps.
It can.
That need to be filled.
You got to build that airtight case.
Okay.
Yeah.
And of course there's causation.
Right, causation.
Which is huge in law.
Huge, yeah.
It's not just did something happen, but were the defendant's actions the legal cause?
Yeah, the legal cause, yeah.
It's like a chain of events.
Yeah, it's like what led to what?
You have to trace it back. Trachtman uses that classic example of a child running into the street and getting hit by a car.
A lot of factors there.
Right, there are multiple factors.
Right.
But who's responsible?
Yeah, who do we blame?
That's such a complex issue.
It is.
It makes you think about all the factors that contribute to any event.
It's not always clear-cut.
And how hard it can be to pinpoint the legal cause.
Exactly.
Okay, what else does Trachtman cover?
So he also talks about expert witnesses.
Oh, yes. Expert witnesses.
They can be crucial in complex cases.
Right, like when there's, scientific evidence.
Right, scientific or technical stuff.
Yeah, we've all seen those courtroom dramas.
Yeah, the experts battling it out.
The expert witnesses clashing.
Right. Yeah.
So Trachtman points out that this testimony can be used strategically.
Oh, absolutely. Yeah.
And he reminds us that even scientific evidence is open to debate.
It's not always as clear-cut as we think.
Science isn't always black and white.
Yeah.
That's a good reminder. It's easy to assume the scientific evidence is just fact.
Yeah. You think, oh, science, it's settled.
But it can be interpreted in different ways.
It can be, yeah.
Okay, what about estoppel?
Oh, estoppel.
That sounds like a Harry Potter spell.
I know, right?
I mean, in legal terms.
Yeah, in legal terms.
What is it?
Estoppel is a principle that prevents someone from making an argument that contradicts what they said before.
Oh, okay.
So it's like you can't have it both ways.
You made your bed, now lie in it.
Exactly.
He gives the example of letters of credit.
Right, letters of credit.
Where a bank might be stopped from saying that a beneficiary didn't, fulfill the conditions for payment. If the bank already accepted the demand or waited too long.
It's about preventing people from changing their story.
Okay.
Holding them accountable.
Yeah.
Yeah.
What about presumption?
Assumptions, yeah.
These are like legal shortcuts.
Kind of. They're legal assumptions.
Okay.
Where the law assumes something is true unless you have evidence to prove otherwise.
Like the presumption of innocence.
Exactly. That's a big one.
Yeah.
Prosecution has to prove you're guilty.
We don't have to prove you're innocent.
Right.
Okay, so arguing about facts is more than just listing what happened.
It's about shaping the narrative. Yeah. It's about choosing which facts to highlight and using these legal tools to influence the outcome.
Okay, so now let's have some fun.
Let's have some fun, yeah.
Trachtman has a whole chapter on rhetorical tricks.
Right, rhetorical tricks.
Those are those sneaky tactics that sound good, but aren't logically sound.
They sound persuasive, but they're not really valid.
They're used all the time, right?
Oh, all the time.
In advertising, political speeches.
Yeah, everyday conversations.
Okay, what are some of the highlights?
Okay, so he starts with non sequitur.
Non sequitur.
Okay.
Which is Latin for it does not follow.
Okay.
Basically, it means drawing a conclusion that doesn't actually follow from your premises.
I remember that from my logic class.
It's a classic fallacy.
It's like saying, the sky is blue, therefore I'm a genius. Like those have nothing to do with each other.
Yeah.
Trachtman gives the example of the OJ trial.
Oh, yes.
Do you remember Johnny Cochran's famous line?
If it doesn't fit, you must acquit.
Yeah, yeah.
So the fact that the glove didn't fit doesn't logically mean he wasn't guilty.
Right, but it worked.
But it was persuasive.
Yeah.
It was a brilliant move.
It was rhetorically, even if it wasn't logically sound.
Right. It shows how these tricks can really sway people.
They can change people's minds.
Even without solid evidence.
It's about persuasion.
Yeah.
Not necessarily truth.
Okay. What about ad hominem attacks?
Oh, ad hominem.
I feel like those are everywhere.
They are, especially online.
Online, yeah.
Yeah.
So that's when you attack the person.
Right.
Not the argument.
Yeah, you attack the person making the argument instead of the argument itself.
Like, you can't trust what he's saying because he's a convicted felon.
Right.
But that might be totally irrelevant to the argument.
Right. It's a diversion tactic.
Yeah, exactly.
Yeah.
But Trachtman points out that not all ad hominem attacks are bad.
Right. Not all of them.
Think if you can show that someone's dishonest.
Right. If they have a bias.
That affects their credibility.
That's fair.
That's fair game.
So it's about context and relevance.
Relevance, yeah.
If someone's character is relevant to the issue, then it's okay to bring it up.
Yeah.
What other tricks are out there?
Okay, so next he gets into fallacies of causation.
Fallacies of causation, okay.
One of the most common is post hoc ergo propter hoc.
Bring on the Latin.
I love it.
What does that mean?
It means after this, therefore because of this.
Okay.
So just because something happened after another thing doesn't mean it was caused by it.
Right.
But people make this mistake all the time.
It's like, I saw a black cat, and then I got a flat tire. Therefore, black cats are bad luck.
Right.
That's superstition.
That's just superstition.
There's no logical connection.
Yeah.
But because they happened in sequence, people assume there's a connection.
We try to make sense of the world. It's a very human thing to do.
It is, yeah.
Trachtman also talks about the difference between correlation and causation.
Yeah, big difference.
Which I think we all need to be more aware of.
We do?
So just because two things are correlated, it doesn't mean one causes the other.
Doesn't mean that at all.
There could be a third factor.
Yeah, a hidden factor.
Like he gives the classic example that ice cream sales and crime rates.
Yeah, they both go up in the summer.
They both go up in the summer.
But it doesn't mean that ice cream causes crime.
Right, exactly. It's the hot weather.
It's probably the heat. Yeah.
Okay. Correlation does not equal causation.
Very important to remember.
What other rhetorical tricks?
Okay, so he talks about inappropriate inferences from limited data.
Okay. Inappropriate inferences from limited data.
Yeah, so it's basically drawing a big conclusion from a small sample size. So it's like saying, I know two people
who got sick at that restaurant. So the restaurant is poisoning everyone.
Right, exactly. But two people out of hundreds, maybe thousands, that's not statistically significant.
Right.
You need more data.
It's about being wary of generalizations.
Yes.
You need the evidence.
You need the evidence, yeah.
What about Occam's razor?
Ooh, Occam's razor?
I've heard that one.
Yeah.
But I'm not sure I understand it.
So Occam's razor says that the simplest explanation is usually the best.
Okay, so if you've got some like convoluted theory.
Right, some crazy conspiracy theory.
You could use Occam's razor to suggest a simpler explanation.
Yeah, the one that makes the fewest assumptions.
Right.
It's usually the right one.
Okay, Occam's razor. Got it.
And then the last rhetorical trick he covers is embedding assumptions in questions.
Oh, this is a good one.
Yeah, it's a classic.
He uses the "when did you stop beating your wife?" example.
Yes, exactly.
So that question assumes that you were beating your wife.
Yeah, it presupposes it.
Which might not be true at all.
Not true at all.
It's like a verbal trap.
It is a trap.
Right. You're trying to get someone to admit to something they didn't do.
To make them look bad.
Okay, so we need to be aware of these tricks so we don't fall for them.
Right.
Or, if we're feeling mischievous.
If you want to be sneaky.
Just kidding.
Yeah, just kidding.
Okay, so we've covered how to think like a lawyer, how to dissect arguments, spot those sneaky tricks.
Right.
But Trachtman goes further.
He does. He doesn't stop there.
He talks about substantive responsibility.
Right.
Which sounds, I don't know, kind of serious.
Yeah, it sounds a bit weighty.
What's that about?
So in the section, Trachtman is shifting gears a little bit.
Okay.
We're moving from those mechanics of argumentation to those underlying principles of responsibility.
Okay.
Accountability.
Got it.
And he starts with the reasonable person standard.
The reasonable person standard. Okay. I feel like I've heard that.
You probably have. It's a big one.
Yeah. What does that mean?
It's about judging someone's actions based on what a reasonable person would do in the same situation.
Okay.
Right? So it's like a baseline for behavior.
Got it.
Considering the circumstances, of course.
Okay. So Trachtman uses the example of the child running into the street.
Right, getting hit by a car.
Yeah, and the jury would have to decide if the driver was acting reasonably.
Right. Were they speeding?
Right.
Could they see the child?
Right. All those factors.
Yeah. Did they take precautions?
Okay.
It's about that totality of the circumstances.
So it's not just about what happened. It's about whether their actions were reasonable.
Yeah, given the situation.
Makes sense. What about due diligence?
Oh, due diligence.
I hear that a lot.
Yeah.
In business.
It's a big one in business.
What is that exactly?
So due diligence is basically that reasonable person standard applied to investigations.
Okay.
So you see it a lot in business deals, especially when buying a company.
Okay, so if you're buying a company, you have to do your due diligence.
You have to do your homework.
And investigate their finances.
Their financials, their operations.
Right.
Legal compliance. Make sure everything's on the up and up.
Right. Because if you don't, and there are problems later, you could be liable.
Yeah, you could be in trouble.
So it's about protecting yourself.
Yeah, protecting yourself and your interests.
Knowledge is power.
It is, especially in these situations.
Okay, so Trachtman then talks about exceptional circumstances, also known as force majeure.
Force majeure, yes.
It sounds very dramatic.
It does.
What is a force majeure event?
So force majeure is when something happens that's outside of your control that makes it impossible to fulfill a contract. It's like an act of God kind of thing.
Like if you're supposed to deliver a shipment, but there's an earthquake.
Right, or a pandemic shuts down everything.
So in those cases, you might be excused from your obligation.
In the contract,
But I imagine there's some debate.
Oh, there always is.
About what qualifies.
Right. What counts as force majeure.
Yeah. It can't just be any inconvenience.
No, it has to be extraordinary.
It's got to be something major.
Yeah, something unforeseeable.
Okay, so it's about drawing that line between what's reasonably foreseeable and what's truly unpredictable.
Right, what's outside of your control.
Okay. Trachtman also discusses form versus substance.
Right, form versus substance.
Which sounds like a philosophical debate.
It does. It's a big question.
Yeah. What's the gist of it?
It's about whether you should focus on the strict letter of the law, the form, or the underlying purpose, the substance.
Okay, I see.
Right? So it's about balancing those two.
So Trachtman uses the example of the U.S. tax system.
Oh, yeah.
Where people are always people are always looking for loopholes, right?
To minimize their taxes.
And the IRS is always trying to close them.
Right. It's a constant battle.
It's like, do you stick to the letter of the law? Or do you interpret the spirit of the law?
Right. What was the intent?
So there's no easy answer.
There isn't.
It depends on the context.
And the values at stake.
Sticking to the letter could lead to unfair outcomes.
It could, yeah.
But bending the rules too much could create chaos.
Yeah, you need some stability.
So it's about finding that balance.
It is a delicate balance.
Okay, now Trachtman also goes into this distinction between law and equity.
Right, law and equity.
Which sounds like a history lesson.
It is a bit of a history lesson.
I vaguely remember this from law school.
So, historically, courts of law were all about the rules.
Okay.
Very black and white.
Okay.
You break the law, you pay the price.
Right.
But then courts of equity developed to address those situations where the strict law would be unfair.
Okay.
They could issue injunctions, other remedies that went beyond just money.
So equity was a way to, like, temper the harshness of the law.
Yeah, to make
sure there was justice.
Yeah, even if it meant bending the rules a little.
Okay. And today, most courts have merged these systems, right?
They have, yeah.
But the distinction still matters.
It still comes up, yeah.
Trachtman uses the example of a homeowner facing eviction.
Right, because they missed a mortgage payment.
Okay, so how would law versus equity play out there?
So a court of law might just enforce the contract and allow the eviction.
No matter what.
Regardless of the circumstance.
Okay, and a court of equity.
Right. A court of equity might consider the reasons for those missed payments.
Okay.
Like, was there a sudden illness?
Yeah.
Did they lose their job?
Right. Things like that.
And they might grant some relief.
So equity is about taking a more holistic view.
Right. Looking at the bigger picture.
Okay.
Yeah.
Considering the human element.
The human side of things.
Okay. It's about understanding that sometimes you need compassion and flexibility to achieve justice.
Absolutely.
Okay. Now, this brings us to another legal dilemma.
Yes.
Rights versus duties.
Oh, that's a big one.
I always think of that quote, you know?
Yeah.
Your right to swing your fist ends where my nose begins.
Yeah, that's a classic.
So it's about recognizing that our individual rights have limits.
They do, especially when they conflict with others.
Right. We can't just do whatever we want.
No, we have to think about other people.
So Trachtman points out that rights often conflict.
They do. All the time.
And it's up to the law to decide which one wins.
Which one prevails, yeah.
He gives examples like freedom of speech versus national security.
Right.
Punishing criminals versus due process.
Yeah, those are tough choices.
These are all fundamental rights.
They are.
But sometimes they're at odds.
Yeah, and the law has to balance them.
It's like a legal balancing act.
It is, yeah. It's tough.
Okay, we're in the home stretch now.
We are.
Trachtman finishes with a chapter on the quirks of the legal mind.
Oh, yes, the legal mind.
I think this is especially relevant for our listeners who might be working with lawyers.
Right, because lawyers are unique creatures.
What are some of the things he highlights?
Okay, so he starts with this observation that lawyers hate to say sorry.
I've noticed that. Why is that?
It's not because they're heartless.
Right, I figured.
It's because legally saying sorry can be seen as an admission of guilt.
Oh, right.
So it's not just about being polite.
Yeah.
It's about protecting yourself.
Every word can have consequences.
Exactly. And then there's the lawyer's obsession with precision.
They love precision.
They do. They love to be very precise with their language.
I've definitely experienced that.
Right. Every word matters.
Yeah.
Trachtman talks about how lawyers are trained to spot those loopholes that are created by language, or, on the other hand, to try to close those loopholes.
So it's like this verbal chess game.
It is, yeah. You're trying to anticipate their moves.
You got to be strategic.
Absolutely.
And this ties into the importance of evidence.
Evidence, yes.
If you can't prove it, it didn't happen.
Exactly. You need that proof.
Right.
You need the evidence.
It's all about building a solid case.
Yeah, you can't just make things up.
You need the facts.
And that goes hand in hand with that lawyerly skepticism.
Okay.
They're trained to question everything.
Yeah.
They want proof.
Which can be frustrating.
Yeah, it can be.
Sometimes.
Yeah, it can be.
But it also ensures that decisions are based on evidence.
Not on assumptions.
What other quirks?
Okay, so he also talks about the role of credibility.
Credibility, okay.
A lawyer's reputation is really important.
Right, if they're not believable, then they've lost.
They've lost the case, yeah.
It's like building trust.
It is. If you have a reputation for being dishonest, no one's going to believe you.
Right, even if you're telling the truth.
Even if you are.
And Trachtman reminds us that even though the goal is to win, you have to do it fairly.
Yeah, you have to be ethical.
Winning at all costs can damage your credibility.
It can. Yeah, it'll catch up to you eventually.
It's about playing the long game.
Absolutely.
Building that reputation for integrity.
So that brings us to the end of our deep dive.
It has been a journey.
It has been a journey.
We've covered so much.
So much ground.
What are some key takeaways?
Well, I think the biggest takeaway is that these tools are incredibly valuable.
Right, not just for lawyers.
Not just for lawyers.
Right, it's for anyone.
Anyone who wants to be more persuasive, anyone who wants to be better at negotiating or just, more confident in dealing with tough situations.
So it's about using logic.
Strategy,
understanding how arguments work.
To achieve your goals.
Yes.
And Trachtman reminds us that the most persuasive arguments are the ones that are based in truth.
Yeah, that are grounded in sincerity.
It's not just about winning. No.
It's about doing it fairly.
Fairly and ethically.
Well said.
So armed with these legal insights and a sense of ethics, you're ready to tackle any debate.
Go out there and argue like the best lawyers do.
Yeah, with logic, with precision.
With a heart full of justice.
And remember, it's not just about winning. It's about making the world a better place.
Beautifully put.
Thank you.
So that wraps up our deep dive into The Tools of Argument.
By Joel Trachtman.
By Professor Joel Trachtman.
A fascinating book.
And remember, listeners, the journey of learning never ends.
It doesn't.
Keep exploring, keep questioning, keep arguing, and keep making the world a better place.
Yeah.
One argument at a time.